Good afternoon, Your Honor. Charles Limley on behalf of the Navigators Insurance Company. I'm going to try to reserve about 8 minutes for rebuttal given the cross appeal. The question presented in the appeal is whether by paying to settle the claim against its insured, Louis Sticco, Navigators effectively forfeited the right for either it or Mr. Sticco to sue the Mincer firm for negligence in its representation of Mr. Sticco. And the answer to that question is no, as has been held in 3 federal court opinions applying Florida law and implicitly by the Florida Supreme Court in the Fremont indemnity case. The trial court effectively ruled that because Navigators paid to shoulder the burden for the alleged negligence of the firm in its representation of Mr. Sticco, the firm's negligence is a wrong without a remedy, either to Navigators or to Mr. Sticco. And that's something the law should not allow. Navigators sued the firm on 2 different theories. It sued the firm alleging that the firm breached the standard of care in its representation of Navigators as coverage counsel to Navigators. And it also sued the firm in its capacity as defense counsel to Mr. Sticco and alleged that the firm breached the standard of care in its representation of Mr. Sticco in connection with the underlying claim. And that Navigator
really was about the bad faith claim, which arguably grew legs because the statutory requirement of complying with just a basic notice of insurance wasn't timely given or given at all, I believe. Is that right?
Your Honor, there was an element of a risk of a bad faith claim. What happened here was there was a horrible car accident. Very early on, there was evidence from what their own experts have conceded were reliable sources, not necessarily conclusive sources, but evidence that the claimant may very well have been grievously injured. He ended up being a quadriplegic and ended up, by their estimate, having somewhere between $5 to $15 million in damages. That wasn't known at the very beginning. So Navigators retained the firm to represent Mr. Sticco in the underlying claim and also to represent Navigators, to look out for the interests of Navigators. And our experts opined that based on the information that was available in April or May of 2008, which is right after the claim came in, reasonably competent counsel should have advised both Navigators and Mr. Sticco of the risk to them that if these injuries turned out to be true, which they did, that they could both face substantial risk of a significant excess judgment, well in excess of the $1 million limit of liability of the...
Wasn't it all triggered, though, by the failure of Navigators' counsel to advise Navigators to respond to the statutory request by plaintiff's counsel? Says, you know, give me your basic coverage information, and that when that didn't occur, plaintiff's counsel basically stopped responding to anything?
Your Honor, none of that was realized at the time. There had been a situation where the plaintiff's counsel had requested the statutory insurance information, and the person who got that request at Navigators frankly looked at the wrong file and sent the person a response saying, I can't find this file, please give me additional information, and the person never responded. And the person who, Mr. Gerber, was counsel initially. Mr. Gerber said when he got that, he started thinking maybe I might be able to have a bad faith case here against Navigators. And so he quit responding, but what he did was he went and retained Dale Swope. Dale Swope, who is a very well-known bad faith lawyer. And Mr. Gerber said from that point on, he would defer to Mr. Swope with respect to the bad faith strategy. And Mr. Swope testified that yes, the fact that Navigators didn't promptly respond to that request for insurance information was what gave them the idea. It's what started them on the path of trying to set Navigators up for bad faith. But from that point forward, their strategy was to not provide Navigators any information so that Navigators would delay in tendering its policy limits, because Mr. Swope testified the longer Navigators took to tender its policy limits, the more valuable their claim became. And that's a classic situation of what is sometimes called a bad faith setup, where the plaintiff's counsel, either because they have some reason to think that there's already bad faith or because they're hoping to find some reason for bad faith, they'll provide a little bit of information and then refused to provide enough information to allow the insurance company to make a decision. And what our experts opined, Chief Justice Wells opined, and also Ralph Marchbank, who's a local lawyer, they both said that the law firm should have recognized that this was looked to be a claimant who, for some reason, was thinking that he might have excess exposure and he might be trying to set the law firm up for a bad faith claim, and should have advised both Mr. Sticco and Navigators of the risk. And it's really two very different things. What was tried in the trial court was the advice that was given to Navigators as an insurance company. And that advice is, Navigators, do you face risk of bad faith exposure based on what we know? And the firm concluded that because the claimant was providing no information, the Navigators did not face bad faith exposure based on what it knew at the time. Now, there's conflicting testimony on that. Our experts said just the opposite. They said they should have known. But at the same time, so...
Did that carry the day with the trial court? What I understood the trial court's basically decision when they granted summary judgment in this case, they basically said there had been no loss. In other words, how can, because, in particular, the insured, whose rights you subrogated yourself to, didn't suffer a loss because you, in fact, paid the claim, you had no cause of action.
That's exactly right, Your Honor. The ruling that we're appealing here, the case that went to trial is the one we were just discussing. The case between Navigators and the firm as coverage counsel to Navigators regarding whether or not Navigators had some exposure for bad faith. The other part of the case against the firm for its negligence as defense counsel to Mr. Sticco was an entirely different set of facts with entirely different expert testimony and a factual record. The court granted the firm's summary judgment on that based solely on its understanding of the law that because Navigators paid to settle the claim on behalf of Mr. Sticco was not injured, and therefore neither Mr. Sticco nor Navigators could sue the firm for negligence in representing Mr. Sticco. None of that, so there was nothing permitted at trial. The court then ruled that there could be no evidence put on at trial regarding the standard of care owed to Mr. Sticco, whether that standard of care was breached, or whether the breach of the standard of care caused Navigators any injury. The only thing that was tried was the other case regarding the advice given as coverage counsel to Navigators. And my friends would like to say that what happened at trial would be dispositive of the trial here. But first of all, that's not an appropriate argument given that we're here appealing a summary judgment ruling that happened before trial. And the review has to be a de novo review of the record that was before the court at the time it granted summary judgment and viewing all facts and inferences in favor of Navigators. But the fact is what was tried was substantially different. The jury heard evidence only of the firm's representation of Navigators as coverage counsel. It was precluded from hearing any of the evidence that Navigators was prepared to put on regarding the standard of care owed to Mr. Sticco as defense counsel, and that the breach of that standard of care caused injury to Navigators. The jury heard none of that. It was asked and answered one question and one question only, and it's at page 1747 of the record. And the question was whether the firm was negligent in its capacity as coverage counsel to Navigators in failing to advise Navigators to tender the policy limit. And the jury answered that question no. It did not make any of the findings that are suggested in my friend's briefs. It didn't say that the firm acted perfectly reasonably, but to the extent that the jury's verdict indicates that Navigators really didn't have any bad faith exposure, then that amplifies the need for the firm to have been giving advice to Mr. Sticco. Because if there's evidence that this person is grievously injured, maybe it's not enough evidence to absolutely trigger an insurance company's obligation to tender its policy limits. But our experts both opined that it was far more than enough evidence of grievous injury to require that the firm sit down with both Mr. Sticco and Navigators and explain to them the risks of excess exposure, explain to Mr. Sticco, if Navigators isn't guilty of bad faith, then you're going to be the one facing the excess exposure. And it should have explained to both of them at the beginning the way bad faith cases work, just like Dale Swope said, the longer they last, the worse they get. And given the potential for extremely serious damages here, which ended up manifesting themselves, it would be in the best interest of both of them at the very beginning for Navigators to tender its policy limits. Because when the policy limits are tendered, the blood is taken out of the water, and the bad faith lawyers move on someplace else. They'll generally take the policy limits if they're tendered earlier. And there's evidence of record that's exactly what happened. The primary carrier here did tender its limits right off the bat. And no one ever asked it for $1 above its policy limits. But so the fact is, if their advice to Navigators was correct, that Navigators had no bad faith exposure, then they really needed to be explaining to Mr. Sticko the risks to him, and that it was in his interest for Navigators to go ahead and tender its policy limits to get the case settled, because he was the one who was sitting in front of the oncoming train. They were gambling with Mr. Sticko's money, and he did not even know the poker game was going on. That was the bottom line. The trial court's summary judgment ruling runs counter to every opinion that's addressed this issue, applying Florida law. As Your Honor pointed out, the trial court's ruling was based strictly on whether or not the Navigators effectively had standing to pursue a claim that the defense counsel breached the standard of care in its representation of Mr. Sticko. And we've cited these cases in our brief, and the other side has as well. Nova Casualty versus Santa Lucia, Hartford Insurance versus Capel, USSIC versus Byrd. All three of these opinions held that where an insurance company pays to settle a claim against its insured, thereby protecting the insured from any injury, it may sue assigned defense counsel for breaching the standard of care in its representation of the insured. And the Capel case goes into great detail, citing cases from throughout the country, and explains that this is by far the majority view throughout the country. In fact, it only identifies one court, one state, Texas, where there is no ability for an insurance company to sue defense counsel under these circumstances. And that's because Texas doesn't recognize the tripartite relationship as...
You're at 12.
Sorry?
You're at 12.
All right, thank you, Your Honor. I'll wrap up quickly. And the Capel case also notes that the Supreme Court essentially, or at least implicitly, came to the same conclusion in the Fremont Indemnity versus Kerry Dwyer case, where the Supreme Court answered a question that was certified to it by the 11th Circuit. The 11th Circuit asked, when does the statute of limitations begin to run? When an insurance company sues defense counsel for breaching the standard of care owed in its representation of the insured, and the insurance company is injured? And the Supreme Court answered that question without ever once suggesting that there was any limitation on an insurance company's ability to do that. So I will conclude with this. My friends have argued that they agree that there's, in some circumstances, an insurance company can sue defense counsel for breaching the standard of care owed to the insured. They say all of these cases are distinguishable. The fact is, these cases are not distinguishable. All four of them allege that the insurance company paid more to settle claims against the insured because of the defense counsel's negligence in representing the insured. All four cases involved insureds who were not injured because the insurer paid to settle the claims against them. Both the Capel and Byrd case involved insurance companies that paid in excess of their policy limits, at least in part to protect themselves from bad faith exposure. And yet in all four cases, the insurers were permitted to present their cases to the jury that they were injured by defense counsel's negligence. We had expert testimony, we had factual evidence, we weren't allowed to present it, and we should have been. Thank you.
May it please the court.
Counsel.
Opposing counsel, Rob Klein, Andrew Feldman, and Klein Glasser for the Minter firm and Mr. Myers. First of all, I think I need to correct one thing, and I apologize for my voice. I'm losing it on and off all day. We're not coverage counsel. The record was clear, and in fact, their entire claim under equitable subrogation is that they're representing both. The firm was retained shortly after January of 2008 because there'd been an automobile accident. Letter was sent, and this is in the record. It's in the record on the motion for summary judgment, to the Mintzer firm saying, represent the interests of our insured. Under the tripartite relationship, as memorialized in multiple decisions in this state, and under Rule 4-1.7E of the Florida Bar Rules, as long as there's a community of interest between the parties, the insurance company and the insured, then the law firm can represent both. So there is no conflict of interest, and that word conflict came up prominently in the motion for summary judgment, and I'm going to get to Judge Pendino's ruling at trial. Fast forward, as has already been pointed out, I think, by Judge Morris, the claimant's attorney sends a letter, coverage demand letter under Florida law, statutory demand, and they make a mistake, which they admitted at trial. They admitted in depositions prior to the summary judgment, which is why we moved for summary judgment on the whole case. And they didn't provide any of the coverage information. Again, in the record, Mr. Swope and his trial court counsel decide that that failure to provide them with any information as to the extent of the excess coverage meant that they would no longer communicate with the insurance company. They would complete their own investigation, ultimately file suit, and they would have no discussions with the carrier because they had refused and continued to refuse. They never provided the coverage information for almost a year. And they specifically said under oath, we had a strategy. If they came in and talked to us, it'd be one thing, but they never did, and they never gave us the information they sought. In the motion for summary judgment that we had cross-appealed, there were 22 cited examples of the Mintzer firm and the outside investigator they hired going to the plaintiff and saying, please give us the medical information, please give us a release. In fact, in what was one of the more absurd bits of testimony I've ever heard in a courtroom, the third-party administrator who was hired by the insurance company went to the plaintiff's lawyer's office and sat there. He parked in his lobby demanding to see him and saying, we need to know about the case. Why? Because as of May of 2008, they had what the insurance people themselves characterized as anecdotal information. They'd heard there were bad injuries, there were $85,000 in damages, but the police report said it was an non-incapacitating injury. They heard he had a back injury. Somebody else said he was in a neck brace but then recanted. Some person said he'd been in the hospital for a week. Someone else said he'd been in for months. But they had nothing solid. And what, in the testimony we cited in the motion for summary judgment that's in the record, the insurance company people said, we can't settle $1 million worth of loss of claims over the 250 that had already been tendered, where we have no hard evidence of, one, what the damages are, and two, their insured is telling them that the other guy had his lights off, was traveling at an unreasonable rate of speed, hit the very rear of his car as he crossed the right-of-way, and there was a legitimate issue as to what caused the accident. Now, what does the Mintzer firm do? The Mintzer firm is not opining on bad faith. The third-party administrator says, look, maybe he's trying to set you up. And what Mr. Myers testified to was, how could there be a bad faith setup, if you will, if they won't give us any information whatsoever about this case? And we've asked for it. As I said, there were 22 documented instances of asking for the most rudimentary information. And it wasn't like they didn't understand the law. They had a free debate with the case law in front of them, the leading cases on point, including the Powell case. Because Powell says if you have clear liability, and that's a big if, and if you have solid information to confirm that the damages are in excess of your coverage limits, you may have an obligation to initiate settlement negotiations. And all Mr. Myers said was, in his opinion, and the insurance company was certainly free to disagree, he didn't think this was a Powell situation because he couldn't imagine any court in this state allowing a bad faith claim to proceed.
But isn't this argument all about, whether the bad faith claim was viable as opposed to really what the trial court did in this case, who said we don't care if it was viable or not. This insured suffered no loss.
For two reasons.
Therefore, his assignment of a case where he suffered no loss to his insured results in a nullity. There's nothing, there's no case to assign, because
Right.
there's no damage.
I think that's certainly one element of the three that we argued, and
That's what bothers me the most.
it's a legitimate one. Because under the case law, and I want to go through those cases that they've cited, by the way, there's no finding by the judge in his order. All it says is my motion for summary judgment is granted.
Yeah.
Well, the motion for summary judgment was on three grounds.
Yeah.
One, you can't assign, under the Stern case, a cause of action for malpractice. And I argued Stern. I also argued the earlier one, Colin Leibowitz, and the Supreme Court took a big step back in Stern and said, essentially, read our lips. Causes of action for legal malpractice are not assignable. Why? Because there are unique issues that apply to a legal malpractice case, because the attorney-client relationship is inviolate, because there are privileges that apply, and a lawyer is put in an impossible situation if he's sued by some third party, and he's got attorney-client communications he may have to assert to defend himself. And what the Supreme Court said in Stern is, we are rejecting this case-by-case analysis. We are going to allow, and frankly, they said somebody should, the Fourth District in particular, should have read our decision in Colin Leibowitz a little more closely. In Colin Leibowitz, they had a 3-page preface before they said, in this limited circumstance, we'll allow an assignment of a legal malpractice case. Why? Because traditional privileges don't apply when you're preparing a limited partnership memorandum specifically for distribution to third parties who are then relying on that memorandum. They said that is a very limited circumstance, and it's no different than an auditor preparing an audit that's relied upon by a bank to lend money. And so at Stern, they came in and said, Colin Leibowitz was very specific, it was very limited, and since that time, there have been no other cases that have allowed assignability of a cause of action. That was ground number one. Ground number two was there could be no claim for equitable subrogation because Mr. Sticko wasn't damaged. And if you'll recall, both sides agree. One of the elements of a claim for equitable subrogation is you have stepped into my shoes and paid a claim that you're obligated to pay. You're not a volunteer. That's the operative phrase. You're paying a claim you're obligated to pay, Mr. Insurance Company, that was caused by something, where the damage to me was caused by somebody else. And I cited to the court Argonaut versus May Plumbing, classic example. Argonaut has property damage coverage. It's insured, has a fire loss caused how? By an arc welder of a plumber that's working on the premises. And Argonaut affirmed the proposition that the insurance company, once they paid its insured's loss, could step into the shoes of the insured and sue the tortfeasor who caused the loss. That's classic equitable subrogation. The Mincer firm didn't cause the loss to Mr. Sticko. Any potential loss to Mr. Sticko would have been because of the accident and whatever damages were caused in that accident that were ultimately assessed against him. Now, counsel says, well, these other cases, and I'll go through them very quickly, are situations where the insurance company was allowed to file suit. Of course they were. No vocabulary, because let's back up. There's no conflict of interest. There's no lawyer saying you're in bad faith, insurance company, or not, because of what the lawyer did in advice he gave you as to whether to settle. In Nova, they decided to settle the case. No debate. Nova retains counsel and says, we're paying $100,000. Go get it done. He doesn't. He makes a number of mistakes along the way. So now, not only is the insurance company, but it's insured on a case they had settled, exposed to an excess verdict because the lawyer didn't document the settlement, where the carrier had already agreed to settle. On the Hartford versus Koppel, same thing. You have, in one of them, there was a high-low agreement that was negotiated. That's the Santa Lucia case. And the insurance company and the insured were only going to be responsible for $250,000, with a maximum, once the full case was completed, of $750,000 within the limits of the available coverage. The lawyer who was charged with the responsibility of drafting that agreement to get it done, again, failed. And a court ultimately found that the agreement he drafted was ambiguous. So both the insured, notwithstanding the agreement that had been reached, and its insurance carrier were exposed to a judgment that was in excess of what they'd already agreed to, because he didn't properly document the claim, the settlement. In neither instance was the argument made that it was up to the lawyer to tell the insurance company whether to settle the case or not. That's what this case is. And every court that we've cited to you has said over and over and over again, that is a non-delegable duty. The lawyer himself can tell the insurance company to settle till they're blue in the face. And under the Trevathan claim, that's an element of whether or not they're in good faith or bad faith. But it doesn't go to exonerate the insurance company. Why? Because the courts have said, starting way back with Boston O'Colony and carrying through Burgess, that you have to look at the totality of the circumstances. So that even here, if the insurance company relied in good faith on the advice of the lawyers that it was not obligated to try to negotiate where they had no one to even talk to, and they had nothing but anecdotal information, a jury could still have found in a bad faith case, for other reasons, that the insurance company should have attempted to settle the case. Maybe the insurance company, for example, as we had in this case, reserved the case for its full policy limits at $1 million before ever asking the lawyers what they thought about the value of the case. Maybe the insurance company didn't have licensed adjusters in Florida, one of the factors in this case. Maybe they were concerned about the fact that they never bothered to tell the claimant's attorney what the policy limits were. Those are all factors a jury's free to look at. But it cannot be, under Florida law, under Trevathan and its progeny, it cannot be because of the lawyer's advice. That does not subject them to if the lawyer's advice was given in good faith and the carrier relying on it, and there's no other bad faith involved, then they're off the hook. Because that's an element the jury's entitled to consider under Trevathan. If the lawyer gave them advice and the jury decides, you know what, there are lots of other reasons why they should have settled this case, then the totality of the circumstances dictate that the insurance company's at fault. If you look at these cases, one after the other, and there's frankly only 4 of them, and they're all from federal district courts. The Quinteros case, which counsel cites, the lawyers had their experts stricken that were defending the case. And the insurance company and the client were then exposed. The law firm had said the case was worth $250,000, and they had a great expert. The expert was stricken. Suddenly, the evaluation jumped from $250,000 to $2 to $4 million. And the court said, in that circumstance, the exposure was created because the lawyer mishandled the case. Not because the lawyer said, in my opinion, this case isn't worth X, Y, or Z, but because his conduct made the case indefensible. He didn't have an expert. So in those 3 unique situations, federal court judges have said, we think in that limited circumstance, because the lawyer and the carrier have a community of interest in getting the settlement done, and they made an effort to get the case settled, and the lawyer's conduct prevented the settlement after a decision had already been made. In each of those instances, we're going to allow a limited cause of action. Why? Because they had a community of interest. Why does and by the way, in each of those instances, the settlement was within the policy limits, and the carrier was obligated to pay that. Think about this. Navigator has absolutely 0 obligation to pay a nickel beyond its policy limits. Counsel makes the gratuitous statement in his brief that they weren't volunteers. Of course they were. If Navigators didn't feel it had done anything wrong and it wasn't operating in bad faith, it had the absolute right to say to Mr. Sticco, and that's where the adverse situation comes in. That's where they're now at odds. They have the right to say to Mr. Sticco, you know what, we're only paying $1 million. We didn't do anything wrong. We never, and frankly, that was the argument to the jury here, was that these guys did everything possible to find out the information they could about the damage and the liability. They couldn't find the vehicles. Turns out one of them was being quietly secreted away somewhere. So they couldn't even assess the accident. They couldn't do accident reconstruction. And we said to the jury, they weren't acting in bad faith. They may have been concerned because they hadn't provided the policy information after receiving a statutory request. But going back to the summary judgment, Judge Morris, every single theory, counsel said these are two entirely different cases. Look at the complaint. Every single paragraph that supports of factual allegations that supports count 1 and count 2 are set forth in detail, identically, and adopted by reference in count 3. They're trying all the same issues. And the only thing that Judge Pendino did, counsel says he made a sudden about face. When there was a point in the trial when they started getting into this conflict issue, and they wanted to tell the jury how the lawyers had a conflict of interest. Well, no, they didn't. The tripartite relationship is founded on the idea that as long as everyone has a community of interest in trying to get a case either settled or tried, whatever the decision is made, then there is no conflict. And the case law has also said the Byrd case is probably, if you look at the materials, has the best lengthy exposition on this whole conflict issue. As long as everybody's on the same page, there's no conflict. And what I said to Judge Pendino, and it's in the record, it's part of the appendix actually to the appellant's brief. When we got to this conflicts issue, and they were going to offer Mr. Marchbank to talk about a conflict of interest that they should have told Stickel about, because counsel was arguing that that was relevant to the lawyer's conduct. And I said, first of all, there can be no conflict, because the case law, including the Byrd case, says that the mere potential of a conflict of interest or of an excess verdict does not trigger a conflict of interest. Otherwise, nobody would ever be able to defend a case that theoretically could go in excess of policy. You'd always have a conflict of interest. And I asked, and first of all, I said to Judge Pendino, first of all, look at Mr. Marchbank's disclosure, which is in your materials, was part of the response to the motion for summary judgment. Marchbank says nothing about conflict of interest, and I pointed that out to Judge Pendino. And it's at page, appendix 030. It's pages 113 to 116 of the transcripts. And I then said, I read what Mr. Marchbank said in his testimony, and I said, do you believe that the mere prospect of an excess verdict creates a conflict? And he said, no. And he's right. That's the law. And then he says, I think the better practice may have been that if there's a potential for a conflict, this is really a potential excess verdict, that maybe you should discuss that with your insured. Quote, having said that, I am not going to say it was below the standard of care, that it was negligent for them to not follow that course. So I moved it limine, and the judge said, granted, I'm not going to let them, first of all, Judge Pendino certainly said, which is quoted to you in the brief, Helen's brief, he certainly said, first of all, this case is all about whether or not they were given good advice or bad advice as to whether or not they should be trying to settle the case. I cited, but he said, this is not about conflicts of interest, and I'm not going to let that go to the jury.
Forgive me for interrupting, but were you going to address any time on your cross appeal, because you're at 18 and a half? I believe you have a cross appeal, and you're at 18 and a half minutes. I don't want to interrupt you, but I didn't know how much time you wanted to go on that one.
No, I appreciate it, Judge. All I wanted to say about the cross appeal, quite frankly, is based on all the cases we've cited in our brief. The idea that an insurance company can be allowed, whether by equitable subrogation, which I don't think could possibly apply in this case, or by assignment, which I do not think possibly could apply in this case, could sue a law firm for failing to tell it to settle a case, would stand the law of bad faith on its head and set it back 40 years. Every major decision out of the Supreme Court of Florida and most other states, quite frankly, is based on the notion that an insurance company has a paramount, non-delegable contractual duty because it takes over the settlement negotiations as part of its policy. And it should not be allowed to sue somebody else saying that we relied on them and to tell us whether or not to settle a case, because that would absolutely do a great disservice. And I cited case law to the effect that breaches of fiduciary duty like that cannot be blamed on somebody else. But the idea that you're going to take all of this law, all of these insurance regulations, you're going to take a case like Boston Old Colony, which was decided 40 years ago, and said that the insurance company has an obligation to tell its insured if it's exposed, even if it's possible and then it has a fiduciary obligation to relay that information to its insured. These people reserve this case for $1 million. They don't tell their insured that. That's their obligation, and it's a non-delegable obligation, and it's part of the panoply of issues that the courts say are taken into consideration when you consider the totality of the circumstances. There should never be a circumstance where a carrier should be allowed to say, we didn't carry out our obligation to our insured because our lawyers told us we didn't have to, because that's their paramount obligation. The lawyer can't settle the case. The lawyer doesn't know what the insurance company knows. The lawyer doesn't have access to the thousands of claims that these carriers look at every day, whereas the lawyers look at a very few. And frankly, their own testimony on the road said repeatedly, we make these decisions, not the lawyers. Sometimes they tell us to settle and we don't. Sometimes they tell us not to settle and we do. That's their right.
Thank you. I'll let you go a little over, but thank you.
Thank you.
Just a
You
couple
have
of
about
points,
6
Your Honor.
minutes left.
Sorry, Your Honor?
You have 6 minutes left.
Oh, thank you, Your Honor. What we've heard here today, and much of what is in my friend's briefs, are the recollections of the prevailing party about a trial that he won, and I don't blame him for crowing about it. But we're here today about the trial that never happened. And it was not the same trial. Certainly the underlying facts regarding the accident were the same, but what was different was the client was different, the standard of care was different, the standard of care evidence was different, the causation evidence was different, the conduct was different, the advice that should have been given was different. All of that was different, and it would be manifestly unfair and frankly a violation of due process for navigators for the trial court to issue a ruling saying navigators cannot present any evidence related to this claim, the claim against the firm as defense counsel at trial, and then to stand up here and use what happened at trial to justify that ruling. This is a summary judgment ruling. Summary judgment is very rarely granted in professional negligence cases where there is expert testimony. We had expert testimony from the former Chief Justice of the Florida Supreme Court, and the jury heard none of it. And the jury should hear it. I would encourage the court to read the Capel case because it goes into great detail citing cases from throughout the country on the public policy reasons why navigators should be able to pursue the claim it's trying to pursue here. Because if navigators can't pursue it, because navigators is paid to relieve the insured of any liability, the insured has no reason to sue defense counsel, and as the courts have said, and I'm quoting, a ruling prohibiting the insurance company from suing under these circumstances would serve the interests of no one except the entity that committed the malpractice. That's quoting from Capel, and quoting from the Great American case in Mississippi, would place defense counsel hired by insurance companies in a special category of protection among negligent lawyers. That is not the law in Florida. As far as Judge Morris, your question about the no loss issue, first of all, that would not even apply to two of the theories. There are 4 theories here, and if we went on any one of them, summary judgment has to be reversed. It doesn't even apply to the third-party beneficiary theory or the direct action, which are the 2 theories that the Capel case relied on, because they are navigators is suing for its own damages. On the other 2, all of the 4 cases we cited and all of the cases that are cited in Capel involve circumstances. In fact, every case where there's a third-party claim and the insurance company is subrogated to the rights of its insured or gets an assignment from its insured, every one of those cases involves a circumstance by definition where the insured has not been injured. Because to qualify for subrogation, the insurer has to pay the entire obligation of the insured. They're never injured. And so the law cannot be what they're saying it is. The court made a mistake on that. And for all the public policy reasons set forth in Capel, navigators should have been permitted and should now be permitted to present its case with respect to the negligence as defense counsel to Mr. Sticco to the jury. And I would just...
How do we then circumvent this problem that appears very well founded in the law that you can't assign cause of action based on malpractice?
Your Honor, frankly, assignment There are 4 theories here. Assignment is probably our toughest one, especially under Florida law. There are several recent cases we cited in a footnote to our brief. I'd encourage you to look at them. Cases from around the country that seem to use the same logic that the Supreme Court used in the Cow and Leibowitz case, and say that where the insurance company is getting an assignment from the insured, because the insurance company, the insured, and defense counsel are in a tripartite relationship, then the concerns that you normally have with assignment of legal malpractice cases isn't present. This is really a case very much like the one in Cow and Leibowitz, because in Cow and Leibowitz, the Stern case said Cow and Leibowitz was all about the attorney-client privilege issue. That's what Stern says.